So this is the kind of question that I get a lot. A collaborator and I came up with the story idea, and then I, acting alone, wrote a script based on that idea. Now that I'm no longer working with said collaborator, can I write that script based on the story idea that we came up with together, or would I be violating my collaborator's copyright by doing that? And the answer, which is a typical answer in the law, unfortunately, is that it depends on a couple of different factors. In this video, I'm going to go through what those factors are and how you can best position yourself to avoid liability for copyright infringement based on the scripts that you write and the scripts that you may buy the rights to. But first, two disclaimers, because we lawyers just can't resist disclaiming things. First, what I'm about to tell you is not legal advice, because if I were going to give you legal advice, I would need to understand the specifics of your situation and your specific needs. And right now, I'm just a random lawyer talking to you on the internet. Second, this is going to deal with issues of U.S. copyright law. So if you are outside the United States or your collaborators outside of the United States, it's possible that a different set of laws might apply to this issue, and this video might not be applicable to you. As always, if you find this content helpful, please remember to like this video and subscribe to the channel in order to help me keep providing this kind of educational content to enterprising young filmmakers like yourself. So back to our question. Let's take a concrete example. Let's say that one day you and your friend were brainstorming and you jointly came up with an idea to write a script about a Western-style movie in the Australian outback rather than the American West. In fact, it turns out that this is already a subgenre of Westerns that's called the meat pie Western. Who knew? But I digress. Anyway, can you write that script and potentially sell it, or make that film yourself, without infringing on any copyright rights held by your friend? The question that we're really asking here is, if you write the script, is your friend now a co-author of the script for copyright purposes, even if he didn't do any actual drafting of the script, and all he did was help you come up with the idea? If he is a co-author for copyright purposes, that means that he will have an equal right to any profits that are derived from the script or any film that's made based on the script, and he will also have the right to authorize other people to use the script to make movies. So it's a pretty important question. I'll start by talking briefly about the legal framework that courts use to decide whether two people are considered co-authors of a creative work, in this case a screenplay, for copyright purposes. This is taken from a case decided by the U.S. Court of Appeals for the Ninth Circuit called Al-Muhammad versus Lee. The courts consider three factors in deciding whether a person is an author of a script for copyright purposes. The first question is whether the person who's allegedly a joint author, that would be your friend in this example, exercised any control over the script. In other words, who's actually writing down the words in Final Draft or whatever script writing software you use, and who's in charge of whether to make changes and what changes get added to the script. If you are solely in charge of those things, a court is likely to see you as having sole control over the script. But if your friend has input into that too, the court will be more inclined to see you two as joint authors. Second, to be joint authors, the authors of the script need to have said or done something reflecting that they intend to be co-authors. For instance, by putting both of their names in the byline of a screenplay. If you wrote both your and your friend's names into the title page of the script under the written byline, that suggests an intent on your part that your friend and you be considered co-authors. If, on the other hand, you only wrote your own name, that reflects that you intend to be the sole author. Third, the alleged joint author's contribution has to have some sort of value to the audience that takes in the work. In other words, ask yourself, would an audience paying to see the movie do so, at least in part, because of the joint author's contribution to the script? This isn't particularly relevant at the stage when you're just writing a script because no film has been made and thus there's no audience yet. So with that in mind, let's consider how this three-factor test would apply in the Western set in the Outback example that we've been talking about. The answer really depends on the specifics of the work that your friend did and your relationship vis-a-vis this project. Let's start with the easiest variation on this hypothetical situation. If all you did with your friend was have a discussion over coffee or beer about a Western movie set in the Outback, but your friend never actually wrote anything, your friend is not likely to be seen as a joint author for copyright purposes. That's because U.S. copyright law doesn't protect mere ideas. In other words, the mere idea of a Western movie set in the Australian Outback is not copyrightable. So it should be fine for you, from a copyright perspective, in this situation, to just write the script and do whatever you can with it. Your friend will not be considered a co-author. Now let's make this example more complicated. Let's say that you write the script and you send it to your friend, and he gives you notes. That is, in Hollywood jargon, he gives you feedback or comments on the script. For example, he might say that a particular character should be better developed, that the scene with the Australian Death Adder snake is too long, that an Australian would say, "How you going?" rather than "How you doing?" and so forth. Let's say that you decide to take his suggestions and you update your script accordingly. Is your friend a co-author of the script in this situation? Most likely no. Why? Let's go back to the three factors that we talked about earlier. Remember that to be a joint author, your friend has to exercise some degree of control over the script. That is, he has to have some kind of say in what language goes into it. But all your friend did in this example is make suggestions to you about the contents of the script, and it was your decision to add them in, not your friend's. In other words, you had the authority to decide what changes to make, if any. This strongly suggests that you are the only author of the script for copyright purposes. In fact, this was the situation in the Al-Muhammad versus Lee case that I talked about earlier. This guy, Jeffrey Al-Muhammad, gave comments on Spike Lee's script for the movie Malcolm X to help Lee make his portrayal of Islam more authentic in the movie. And Lee incorporated some of Al-Muhammad's comments into his draft. Then, of course, Al-Muhammad turned around and sued Lee and claimed that he was the co-author of the script and he was therefore entitled to millions of dollars. But the court ruled that because Lee had control of the script, including control over whether to accept or reject Al-Muhammad's comments, Al-Muhammad didn't become a joint author just by giving Lee notes. Now let's consider a third possible situation. Suppose that you and your friend working together write out a treatment for the movie. That is, a fairly detailed outline of the plot, with descriptions of characters and names of characters and so forth. But your friend later decides that he doesn't want to be involved in working on the script. If you go and write the script based on the treatment that you and your friend prepared together, does your friend become an author of the script or a joint author of the script for copyright purposes? The broad answer is, again, a frustrating one that we usually give in the law, which is maybe, depending on the extent to which there are, quote, articulable similarities between the plot, themes, dialogue, mood, setting, pace, characters, and sequence of events, unquote, in the treatment, and the same kind of elements in your script. There I'm quoting from the U.S. Court of Appeals for the Ninth Circuit's decision in Funky Films Incorporated versus Time Warner Entertainment. In other words, how similar are the story, dialogue, setting, and characters described in the treatment to those that are in the script? One important thing to say here is that generic similarities between the treatment and the script aren't going to count. For instance, let's say that the Outback Western treatment that you wrote with your friend takes place in a small town in the desert, and there's a gunfight in it. And let's say that the same is true of the script that you eventually write. That alone is not going to make your friend a joint author of your script, simply by virtue of the fact that he co-wrote the treatment. Why? Because almost every Western takes place in a remote town in the desert, and there's at least one gunfight in it. In other words, those are generic similarities that are shared by almost every film in the Western movie genre. To illustrate this point, there was a case about the TV show Rachel Ray on the Food Network that dealt with a similar situation. The plaintiff, that is, the person who filed the lawsuit, submitted a treatment for a possible TV show called Showbiz Chefs to the Food Network, which was supposed to show celebrities cooking their favorite dishes in their own kitchens. The Food Network didn't make the Showbiz Chefs show, but it did go on to make the Rachel Ray cooking show. The plaintiff sued the Food Network saying, hey, you must have based the Rachel Ray show on my treatment, and so you must have infringed my copyright by producing the show. The problem with the plaintiff's case was that the only similarities that she could really point to between the Showbiz Chefs TV show that she wrote the treatment for and Rachel Ray was that they both had hosts and celebrity guests and they involved cooking. Those factors, the court said, are part of virtually every cooking show. The similarities between the treatment and the script, in other words, were generic. So if the court had ruled in the plaintiff's favor, the court would have effectively granted the plaintiff a monopoly over the entire cooking show genre, which would have been crazy. And it's also important to say that just having the same broad story premise as a pre-existing film or TV show won't infringe the copyright held by the owner of that movie or show. For example, there was a little-known writer named Ted Burkick who submitted a treatment to MGM for a movie about a criminal organization that removes people's organs and sells them to people in need of transplants. Later, Michael Crichton, the well-known writer, wrote a script called Coma, which got made into a film based on the same premise. Burkick sued Crichton and MGM, but the court said that the mere fact that Crichton's script shared the same basic premise as Burkick's treatment wasn't enough to make the script infringing. So in other words, the mere fact that your script and the treatment that you prepared with your friend have the same sort of story premise, isn't going to mean that you're going to be declared joint authors for the purposes of the Copyright Act when it comes to your script. But going back to our earlier example, what if the similarities between the treatment and the script are more unique and distinctive and less generic? Let's say that in the treatment you wrote with your friend, the main character is a rancher in the outback. A railroad company wants to buy his land, but he won't sell. And so the corrupt mayor of the small town hires thugs to drive our hero off of his land, which sends our hero into his quest for revenge. Also, he adopts a pet Death Adder snake that he can send after his enemies. All of this, except possibly for the fact that the main character wants revenge, is highly specific and not generic for the Western movie genre as a whole. If you use these elements from the treatment in your script, you may be running the risk that your friend will be considered a co-owner of the copyright in the screenplay, with all the problems we've discussed that come with that. So in this example, if you want to write your script, you want to do your best to scrub the script of any distinctive elements from the treatment that might be in there before you try to sell the script or you try to make the film. Now, for our last hypothetical example, suppose that you and your friend write an actual script together, and there's no question in that situation that you're joint authors of the script. But then you have some sort of spat, you have a falling out with your friend, and you decide that you're not going to do anything with the script that you two wrote. Instead, you want to write your own Western script that's set in the outback. Can your ex-friend claim that he's the co-author of that script too? And again, the answer is, frustratingly enough, it depends. It depends on how similar your new script is to the old script. If the only similarities between the two scripts are generic ones, like we've talked about, for instance, the fact that they're in small desert towns and they involve a gunfight and so on, that's not going to be enough to make your friend the joint author of your new script. In the same vein, the mere fact that both scripts are Western set in the outback is not going to be enough by itself either. But if there are more distinctive similarities, like the ones I talked about before, for instance, the story about the mayor running the main character out of town so the railroad can get built, a court is more likely to find that your friend or your ex-friend is a co-author of your script. If your new script actually uses lines of dialogue from the old script, which of course you obviously shouldn't do, that will create the same type of risk. This is why it's important to make sure, if you're in a situation like this one, that you carefully go through your new script and you make sure to remove any dialogue that may be left over from the old one, and also to remove, to the extent possible, the elements that make the old script distinctive. In other words, if you are just bound and determined to make a Western about the Australian outback in this situation, make sure that it's as different as possible from the old script that you and your friend collaborated to write. Finally, I'll make the overarching point that the cleanest way to deal with situations where there's any kind of collaboration regarding a script is to have the collaborator sign a written agreement, which is often called a collaboration agreement. The agreement should make clear who the author or the authors are. In this example, it might say that you will be the sole author for the purposes of the Copyright Act. Or it might say that you and your friend are going to be considered joint authors if that's the arrangement that you've made. If you do this, that greatly decreases the risk that you're going to have to battle it out in court with your friend or your ex-friend later on. So I hope this was helpful to you in understanding how to avoid liability for copyright infringement when you collaborate on a script, and thank you for watching.